Thanks everybody for joining us. We're here with two very special speakers, Alphonse Provenziano and Sarah Clark, to speak on palimony actions, Marvin actions, and family law proceedings. So we're going to have a great program set for you today. Just a few introductory matters. I would be remiss if I did not mention that we have a Beverly Hills Bar happy hour going on February 5th at 6 p.m. In Beverly Hills. And this is a cross-practice networking night with the family law section, the entertainment law section, and the litigation sections. And that's at Above 60 in Beverly Hills. Great opportunity. It's something that we're trying to stress is kind of doing some cross-pollination between the family law section and other adjacent sections like entertainment and litigation. So great networking opportunity. We have some additional upcoming CLEs on calendar for you. On the 28th, tomorrow, we have international family law, Islamic law, and international family law matters. On the 2nd of February, we have everything you need to know about California's new joint petition. That's the petition for dissolution. On February 4th, we have the Four Corners event, the 2025 annual family law case update. And last but not least, on March 11th, we have CLE on bifurcation issues featuring Aaron Gray and Judge Luna. So a lot of great programming coming up. Stay tuned for all of that. The family law section is sponsored by White Zuckerman, Warsofsky, Hunt, Luna, LLP, and SoberLink. White Zuckerman provides a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. We invite you to contact them to discuss your specific accounting needs and learn how they can be of service to you. Learn more at wzwlh.com. SoberLink provides objective real-time data that can be used to reduce disputes over alcohol consumption, leading to less conflict in custody cases. To help ensure smoother negotiations for a more efficient legal process, consider using SoberLink's trusted alcohol monitoring system to eliminate hearsay and protect your client's best interests. With an unprecedented combination of features, including advanced reporting, facial recognition, tamper resistance, real-time results, and customized testing, the discrete system has been the leader in remote alcohol monitoring since 2011. Learn more at soberlink.com. Well, I am delighted to introduce our speakers, Sarah Clark, and our moderator today, Al Provenziano. Sarah C. Clark is an attorney at Goldstein Clark, an associate where she has devoted the past 17 years of her practice exclusively to family law and specifically palimony actions. Throughout her career, Ms. Clark has advised and represented hundreds of individuals in complex Marvin claims, many of which involve significant crossover issues with traditional family law matters, including division of property, spousal support, and breach of fiduciary duty. Her practice regularly involves high conflict and high asset disputes, requiring a sophisticated understanding of both family law principles and the contractual and equitable doctrines that govern non-marital relationships. Ms. Clark is licensed to practice law in both California and New York, giving her a broader perspective on complex multi-jurisdictional matters. Al Provenziano is a prominent divorce and family law attorney and the founder of Provenziano and Associates, Beverly Hills law firm, focused exclusively on family law matters. He handles high stakes, high net worth matters, including complex divorces, international custody disputes, cross-border asset division, and prenuptial and postnuptial agreements. And he's also known for his strategic advocacy and financial acumen. CFLS and former deputy district attorney, I didn't know that out. He's handled more than 2,000 matters and over 220 trials since 2004. That's a lot. Provenziano is a fellow of the IAFL and serves as president-elect of the Beverly Hills Bar Association. He earned his undergraduate degree with honors from UC Berkeley and his JD from UC Law San Francisco, formerly known as UC Hastings. He's also a frequent speaker and featured as a legal media expert at national and international law outlets. With all of that, now let's take it away, Al and Sarah.
Thanks so much, Ryan, and thanks for the intro. And I wanted to welcome Sarah. Thank you so much for this class. And I know it's one of the things that you've done is that you've trained under uh, Harry Goldstein, who was also trained by and assumed the caseload of Marvin Mitchelson, who is the counsel for the plaintiff in the landmark Marvin case, giving you the benefit of more than 40 years of accumulated experience dating back to the very beginning of Palimony litigation. And we're very excited to have this course here at the Beverly Hills Bar Association. From your standpoint, as a practical matter, Sarah, why is palimony an area that family law attorneys really can't afford to overlook anymore?
Well, thank you, Al, for that intro, and good afternoon, everyone. I'm sure it's no surprise to anyone here that over the years there has been an increase in long-term non-marital relationships. And palimony claims can often come to light during the pendency of a dissolution action or a parentage action. So, as a family law practitioner, it's very important to be able to recognize a potential palimony claim so you can properly advise your client and ensure they don't inadvertently allow a statute of limitations deadline to expire. And it's also important to be able to recognize whether your client has exposure to a palimony claim being filed against them and how best to protect their interests and prepare a solid defense.
And why is it important for practitioners to remember that Marvin claims are grounded in contract rather than family law, Sarah?
Yeah, so at its core, a Marvin action is a civil breach of contract claim filed in civil court and is not a family law proceeding. So they're treated very differently. And I know that's a bit perplexing since the discussion regarding palimony claims is contained in the family law guide of the Rudder Group, but under no circumstances will a Marvin claim be subject to the family code. They are governed entirely by statutory law and case law regarding contracts. And, for all intents and purposes, though, they do involve very similar issues as dissolution actions in that you're essentially untangling the finances and real property holdings between two parties. Those parties just happen to be unmarried. So let's start by discussing the case that really put palimony on the map in California, which was the Marvin versus Marvin case. And that was a case from 1976, which addressed whether an unmarried cohabitant could enforce financial and property rights against a former partner after the relationship ended. And the Marvin case involved the plaintiff, Michelle Triola, and the defendant, Lee Marvin, who was an actor. And not to be confused with Michelle's attorney in the case, Marvin Mitchelson. So there are a few Marvins involved in this one. So the plaintiff, Michelle Triola, alleged that she and her former partner, Lee Marvin, entered into an oral agreement whereby they agreed they would hold themselves out to the general public as husband and wife. Lee Marvin would provide support to Michelle for the remainder of her life, and they would essentially share equally in all property accumulated during the relationship. And in exchange, Michelle agreed that she would give up her career and perform domestic services for Lee Marvin as a companion, homemaker, housekeeper, and cook. And the parties did live together for 7 years. And during that time, Michelle used the last name Marvin. They did hold themselves out as a married couple. Michelle also gave up her lucrative career as an entertainer and a singer in order to devote her time to rendering these domestic services to Lee Marvin. And during their relationship, substantial real and personal property was acquired, including fairly significant motion picture rights. All property was acquired solely in Lee Marvin's name, however. So when the relationship ended, Lee Marvin supported Michelle for about another year until he refused to provide her with any additional support. At which point, Michelle then filed a civil lawsuit against Lee Marvin, alleging breach of their express contract. And so when the Marvin court considered Michelle's claim, it had to kind of strike a balance between case law that treated contracts between unmarried partners as unenforceable if they were based on an illicit relationship, and the existing line of cases recognizing that non-marital partners could still bring claims against each other concerning property rights. And they looked at cases, the Marvin case looked at other cases like Trutali versus Meraviglia. And in that case, the parties had lived together for 11 years. They had two children. They agreed to pool their earnings and hold property jointly. That court found that living together in a quote, unlawful relation didn't disqualify the parties from entering into a lawful agreement with one another regarding ownership of property that was acquired during their relationship. So, similar to the Trutali case, the Marvin court essentially rejected this notion that public policy automatically barred the enforcement of agreements between unmarried partners. And the Marvin court found that adults who voluntarily live together and engage in sexual relations are nonetheless as competent as any other persons to contract, respecting their earnings and property. They may agree to pool their earnings and to hold all property acquired during the relationship in accord with the law governing community property. Conversely, they may agree that each partner's earnings and the property acquired from those earnings remain the separate property of the earning partner. So long as the agreement does not rest upon illicit meretricious consideration, the parties may order their economic affairs as they choose, and no policy precludes the enforcement or the courts from enforcing such agreements. So even though Michelle Triola ultimately did not win her case against Lee Marvin, the decision did have a lasting impact, and it opened the door for future palimony claims and is now widely recognized as the foundational case for all palimony actions, hence the term Marvin actions.
And Sarah, can you speak to the evidentiary challenges that may arise when an agreement is implied rather than expressed?
Sure. Let's let's talk about. Oh, Al, could we go back
Oh, yes.
to
Did
the
you?
perfect?
Right.
Yeah. So let's talk a little bit about um, the elements of a breach of contract claim. So now that we know Marvin actions are civil breach of contract claims and are enforceable between non-married cohabitants, there are some key elements that must be present in any contract claim and some elements that are unique to palimony claims. So let's take a look at those. The first element in any breach of contract claim is the existence of the agreement. And basic contract law tells us that there are three types of agreements. The first being a written agreement. And while it's always amazing when two unmarried cohabitants have a written agreement memorializing their understanding regarding support and property, it's rarely the case that you actually see a written agreement in a palimony type situation. And the most common type of palimony claims are based on express oral agreements. And as you can imagine, those can be difficult to prove because it often comes down to one person's word against the other. And the third type of agreement that is quite common in the Marvin context is an implied agreement. And as the Marvin court stated, the courts may inquire into the conduct of the parties to determine whether that conduct demonstrates an implied contract or implied agreement of partnership or joint venture or some other tacit understanding between the parties. So what this essentially means is that an agreement to provide ongoing support or to share in all property equally can arise based on how the parties have conducted themselves and their financial affairs during the relationship, even in the absence of any express representations. So now to answer your question about evidentiary challenges in these implied agreements, They can be difficult to prove. And a palimony plaintiff is typically relying on third-party testimony. Many times, one partner has repeated these promises of financial support or property sharing to friends and family members. You'll also want to look closely at the parties' communications, such as emails, text messages, greeting cards, even social media posts, to see whether those promises show up in writing anywhere. So, in terms of um, evidence in an implied Marvin agreement, it typically involves the parties having a quote marriage type relationship. And maybe one party is using the other's last name. They could be wearing wedding rings. Perhaps they had a religious marriage ceremony, or they're simply holding one another out as spouses. And that marriage type relationship is usually coupled with other conduct relating to their finances and property. And so, some conduct which can be demonstrative of an implied agreement is where the parties have joint financial accounts, joint credit cards. They might hold joint title to property. They may have filed their tax returns as married. They may have signed a declaration of domestic partnership. And that's not necessarily the declaration of domestic partnership that's filed with the Secretary of State. Many parties will complete these forms for their employers in order to obtain health insurance benefits for their partner. And those declarations can be quite informative because they very often can contain express representations confirming cohabitation, joint ownership of property, and responsibility for support and living expenses. So if you're trying to prove a palimony claim, that can be a great piece of evidence. You might also see a party identifying their partner as a spouse in order to obtain other benefits. For example, maybe listing them as a beneficiary on their life insurance or their retirement accounts. You might also see a will or trust that has been drafted or executed where the other party is named as a beneficiary to memorialize the promises of support and property division in the event of death.
And you've listed several indicators that the courts look at, Sarah. How much weight does any single factor usually carry with the court? And are there particular facts that you find courts find especially persuasive when looking at a implied agreement?
So it's important to keep in mind that none of these actions or behaviors are strictly required. And there isn't one that necessarily carries more substantial weight. If they didn't have joint accounts, for example, that alone is not going to be fatal to a palimony case because sometimes even legally married parties have separate accounts. If the parties were married before to other people, you may want to inquire as to how they handled their financial affairs during their marriage to see how similar or different that is to the palimony relationship. And you really just have to look at the totality of the parties' relationship and whether their conduct demonstrated some type of implied agreement. Okay. So let's talk about lawful consideration, which is the second key element for a breach of contract claim. And in the Marvin context, you usually see two very common types of agreements. One is a pooling agreement where the parties pool their income and earnings to acquire property together. And the second very common type of palimony agreement is one where one party essentially promises to be the breadwinner for the relationship and promises to render the other party financially secure by providing lifetime support and equally sharing all property that's acquired during the relationship. And in exchange, the other party agrees to provide homemaking or domestic services. And these domestic services can be anything from cooking the meals, doing the laundry, doing the dishes, caring for children, caring for pets, or assisting the other party in their business. And as the Marvin case told us, a promise to perform homemaking services is lawful and adequate consideration for a contract. Otherwise, those engaged in domestic employment could not sue for their wages.
But how does this consideration, how does it differ from a more traditional contract dispute?
So, in many ways, it really doesn't differ that much at all. As long as the consideration is lawful, a Marvin claim is analyzed just like any other contract dispute, and the court is going to look at the same basic principles of contract law. So the cohabitation requirement is very unique to Marvin actions. And as the Bergen versus Wood case stated, cohabitation is necessary not in and of itself, but rather because from cohabitation flows the rendition of domestic services, which services amount to lawful consideration for a contract between the parties. And the rationale there is that a party would not be able to perform these domestic services for the other party on any consistent basis if they did not live together. There
And
is one caveat here, though, that I do want to make clear, which is that the cohabitation requirement in Marvin's situations only applies to the scenario where domestic services are being performed as consideration for the agreement. If it's purely a pooling agreement of money to acquire property, then the lawful consideration for the agreement is the contribution of those funds. So cohabitation wouldn't necessarily come into play.
is there any practical issues that arise when cohabitation is disputed?
Well, I will say that cohabitation is not an issue that is frequently disputed, and it's usually fairly easy to prove whether the parties were living together, whether that's by third-party testimony or other documents reflecting joint residency. Okay, so if you have a Marvin situation where domestic services are the consideration for the agreement, although cohabitation is required, full-time cohabitation is not. Part-time cohabitation can be enough. And the case that best illustrates that is the Cochran versus Cochran case. And in that case, the parties were in a long-term relationship that lasted 17 years. They lived together about 2 to 3 days per week, and they held themselves out as husband and wife. They raised a child together, and they owned a joint home. And the court held that that level of cohabitation, just 2 to 3 days per week, was sufficient to support a Marvin type agreement. And the Cochran court specifically stated that the purpose of Marvin was to permit parties to a significant and stable relationship to contract concerning their earnings and property rights, to require nothing short of full-time cohabitation before enforcing an agreement would defeat the reasonable expectations of persons who may clearly enjoy a significant and stable relationship arising from cohabitation, albeit less than full-time living arrangement. For instance, it would exclude otherwise valid support agreements made by parties who, perhaps because their jobs are geographically far apart, maintain a part-time residence for one party and also a second residence where at times they live jointly. Certainly, the rationale of Marvin does not support such a result.
And how does the holding of Cochrane affect clients whose relationships don't fit a traditional mold?
So the ruling in Cochrane really acknowledged that relationships don't always fit a traditional mold and that the cohabitation can take many different forms. So whether the parties to a Marvin agreement have satisfied the cohabitation requirement is really going to be fact specific to their particular situation.
And obviously, there's a part about breach. Turning to that, when does a Marvin agreement typically fail from a legal standpoint?
Yeah, so let's talk about that third key element of a Marvin claim, which is the breach. So in general, in terms of general contract law, the breach of an agreement occurs when the party charged with the duty to perform under the contract ceases to perform. And typically, a Marvin type contract is breached when one party terminates the relationship. And this is usually because non-performance under the agreement typically coincides with the end of the relationship. And in practical terms, non-performance will often manifest when one party ceases providing financial support or cancels credit cards, terminates health or automobile insurance, or takes any other action that effectively withholds promised financial support to the other party.
And is there situations that you could elaborate on how continued performance affects the accrual of a claim?
Yeah, so while Marvin claims are often breached at the termination of the relationship, that breach does not always happen at that time. Since a Marvin cause of action does not accrue until the agreed upon performance stops, if the parties are separated and the obligor continued to perform as required by the contract, then there's been no breach. And this is a concept that was once again reflected in the Cochran case. And remember, in that case, the plaintiff and defendant had a child, lived together as if they were husband and wife. The plaintiff in that case had alleged that the defendant promised her that all property acquired during their relationship would be joint and that he would provide her with lifetime support. So, fast forward 20 years, when the defendant married another woman and the parties ceased living together. Um, that okay, he can actually continue to financially support the plaintiff for another 9 years after the relationship ended. So when the financial support eventually stopped, the plaintiff then filed a Marvin action alleging breach of contract for lifetime support. And so the Cochran court held that the statute of limitations for a breach of a Marvin agreement to provide support does not commence to run until the support payments cease, notwithstanding that the parties may have separated years earlier. So once again, that date of breach is going to be very fact specific in a Marvin claim and does not always coincide with the termination of the relationship. And continued support in a Marvin situation will prevent the statute of limitations from running.
And what kind of common claims do you see pled alongside Marvin actions, and how does that shape overall strategy?
Yeah, so once you've been able to analyze the core Marvin agreement in any given case, you'll want to determine what additional claims and remedies might be available to a Marvin plaintiff. And there are some that can be quite common. The first being a breach of partnership or joint venture. And this can be common when parties are operating a business together. Many times, you'll see a business that's placed in only one party's name, but both parties are holding themselves out as founders of the company and devoting their time to working for the business. Fraud claims are also quite common, where one party has made representations of property sharing or financial support, which are later discovered to be false. And this can happen in situations where the parties have made express representations about sharing property together, even if property is only titled in one of their names. And later, the non-title holder discovers that the other party never intended to equally share that property. And that's usually discovered when you review communications with third parties during the relationship, or if the title holder had drafted a will or a trust during their relationship that contradicted the terms of the parties' relationship.
And
Specific performance is also available to a Marvin plaintiff. In situations where damages are inadequate, a party can elect to pursue specific performance of a property agreement with respect to either real property or property with sentimental value.
now there's such a thing as a resulting trust and a constructive trust. Sarah, can you distinguish those for us and how they apply in a Marvin claim case?
Sure. Both resulting trust and constructive trust are remedies that are available to Marvin plaintiffs. And a resulting trust is usually implemented when property is transferred to one party and the consideration is paid, whether that's either in whole or in part by another party. Um, so for a resulting trust, the consideration does not have to be money. A party's rendition of domestic services that allows the other party to save on costs and increase their own financial base and ability to purchase property can give rise to a resulting trust. In the context of a constructive trust, that is typically implemented when property has been wrongfully obtained or retained, whether that's by fraud, accident, or mistake, and prevents unjust enrichment. And you might see that in a scenario where there's a piece of property owned by one party prior to the relationship, and for one reason or another, that property is temporarily transferred to the other party with the intent that it would be transferred back, but it never is. Or you could see a situation where during the relationship, one party inadvertently signs a document that they later discover was a quitclaim deed, where they have transferred their property to their former partner without ever knowing. Okay, an equitable lien is also available to Marvin plaintiffs, and that is a court-recognized security interest imposed on specific property to secure performance of an obligation without actually transferring ownership. And this is a remedy that prevents unjust enrichment where property is not acquired, but maybe the value of the property is increased. And this type of remedy can be appropriate in situations where maybe there's a property, once again, that was acquired by one of the parties previous to the relationship, but the parties reside there during the relationship, and the non-title holder contributes a significant amount of money towards improvements and repairs. And in that situation, a party may be able to pursue an equitable lien against the property for reimbursement. Declaratory relief is also available to Marvin plaintiffs, which is a judicial determination establishing rights of the parties that are in dispute. And again, exactly what type of declaratory relief any given Marvin plaintiff is pursuing will really be fact specific to their situation.
In what situations do the courts seem most receptive to these other forms of relief?
Well, usually courts are going to be more receptive to implementing this form of relief when there's fairly egregious inequity and unjust enrichment, because again, these Marvin claims are mostly equitable in nature.
And is there situations when quantum meruit becomes a viable alternative to a contract-based claim?
Yes, so a quantum meruit can always be pled in the alternative to relief as part of a breach of contract claim. And as the Marvin court stated, a non-marital partner may recover in quantum meruit for the reasonable value of household services rendered, less the reasonable value of support received, if he can show that he rendered services with the expectation of monetary reward. And it's important to know that the law does not presume that compensable services are rendered between non-marital partners with donative intent. So If a party is alleging a defense to a quantum meruit claim that the services were rendered as a gift, they will need to demonstrate specific proof that it was actually intended to be a gift. And it's also important to understand the correct measure of quantum meruit recovery is is the value of the beneficial services, not the value by which someone benefits from those services. So the most notable case involving a quantum meruit claim in the Marvin context is the Maglica case. And in that case, Anthony Maglica was involved in a romantic relationship with the plaintiff. They began living together, holding themselves out as husband and wife, and plaintiff began using the last name of Maglica. The parties worked together at Anthony Maglica's business, which was always in his name. And during the relationship, the business began manufacturing flashlights, which some of you may be familiar with, the Maglite flashlight. And the plaintiff in this situation did contribute some great ideas for the business, including a little purse-sized flashlight. And the business was very successful and lucrative during their relationship. So when plaintiff later pursued a quantum meruit claim against Maglica, she was initially awarded $84 million as the reasonable value of her services. But the appellate court reversed that, saying that the $84 million award was based on the resulting benefit to Maglica and the success of the business, rather than the proper measure of recovery, which was simply the reasonable value of the services that were performed by the plaintiff. So, as a practical matter, though, it's always a good idea to plead quantum meruit anytime compensable services have been performed during a Marvin type relationship.
And what does this tell us about the importance of tailoring the remedies to the facts and whether or not this is an exhaustive list of remedies?
Yeah, so it is important to understand that these claims and remedies are not exhaustive, and most Marvin claims are equitable in nature. And the Marvin court stated that where existing traditional remedies prove inadequate, trial courts may fashion additional equitable remedies to protect the parties' reasonable expectations, and the suitability of such remedies may be determined in later cases in light of the factual setting in which they arise. So, whether someone has a palimony claim and what specific claims they might bring really depends on the unique facts of their situation, as well as the agreements made during the parties' relationship and how they conducted themselves. It's also very common to see additional claims alongside a core Marvin breach of contract claim. For example, a Marvin plaintiff might also bring real property claims like quiet title or partition. And if the parties ran a business together, you might also see claims for accounting, conversion, or breach of fiduciary duty. And depending on a person's age, financial elder abuse claims can sometimes be a part of these cases as well. And so the takeaway here is that spotting and evaluating all potential claims very early is going to be critical in a Marvin case.
And just talking a little bit about statute of limitations for us, Sarah.
Yeah. So now that we've covered what a Marvin claim is, let's shift to some of the defenses. Like any contract case, Marvin claims are subject to the usual affirmative defenses, but there are a few defenses that tend to come up quite frequently in these cases. The first being the statute of limitations. And if you have a Marvin claim for breach of written agreement, the applicable statute of limitations is going to be 4 years from the date of breach. If you have an oral or implied agreement, that statute of limitations deadline is going to be 2 years from the date of breach. And the same with a quantum meruit claim, 2 years from the date of breach. All other equitable claims, like for example, constructive trust or resulting trust, those are going to have a 4-year statute of limitations.
Are there any pitfalls that attorneys should be aware of when they're calculating the accrual of dates for the statute of limitations?
Yes, so parties need to be very careful about pursuing a Marvin claim promptly so it doesn't expire. And it's especially important for the plaintiff to be transparent with their attorney and for the plaintiff's attorney to do their due diligence and review all communications between the parties. Sometimes there are emails, text messages, or statements where the other party has clearly indicated that all property belongs solely to them. And when that happens, the statute of limitations can start running even before the relationship officially ends. So anytime one party takes a position that directly conflicts with the Marvin plaintiff's understanding of the agreement, the clock starts ticking. And if that plaintiff doesn't act quickly, they risk waiving the claim and giving the defendant a strong statute of limitations defense. And no plaintiff's attorney wants to find out in the middle of litigating a Marvin case that evidence like this exists. And yes, it does happen. I have seen situations where in Marvin claims that predate a legal marriage, you're 6 months into litigating the Marvin case, and the other side produces a premarital agreement that the parties sign to memorialize all of their separate property. And that is essentially fatal to a palimony claim. So it's very important to have transparency with your client and to do your own investigation.
And can you explain why the statute of frauds is less effective as a defense to a Marvin claim?
Sure. So the statute of frauds is another common defense when real property is involved because the statute of frauds requires agreements relating to the sale or ownership of real property to be in writing. And since Marvin agreements are typically or express oral agreements, the statute of frauds can bar enforcement of the agreement. But one way for a Marvin plaintiff to try to overcome a statute of frauds defense is by alleging detrimental reliance. And in other words, that these Marvin plaintiffs have relied on the other party's promises to their detriment. And this can be a very significant part of any Marvin claim. You will often see this in long-term relationships where one party has given up their career, stayed home to raise the children, supported the other partner in their professional life, and 20, 30 years down the line, the relationship ends, and the Marvin plaintiff might find themselves in a position where they have no property in their name, no retirement, no employment history, no established credit, and they've made no contributions to Social Security for many years. So, in situations like that, the consequences can be truly devastating. So, that's why courts will allow plaintiffs to rely on equitable estoppel to prevent the other party from using the statute of frauds as a defense when the plaintiff clearly relied on promises to their detriment. And as the Marvin case noted, most cohabitation agreements are express oral agreements. So many other cases have expressly rejected defenses to such agreements that are grounded on the statute of frauds. And the Byrne versus Laura case also addressed this issue and said that in light of Marvin's endorsement of equitable remedies to protect the expectations of the parties to a non-marital agreement, the court's observations on the enforcement of oral cohabitation agreements can only be interpreted as an approval of the use of equitable estoppel by cohabitants in appropriate cases.
And there's a particular case, the case of Taylor versus Fields. Can you tell us what lessons that practitioners should take regarding consideration from that case?
Absolutely. So, another common defense to Marvin actions is a lack of lawful consideration. And this can be a very successful defense if a contract is expressly in and inseparably founded upon a meretricious relationship. And in those circumstances, the contract will be invalid and unenforceable. And Taylor versus Fields is one case that really highlights this situation where a Marvin agreement will not be enforced. And in that case, the plaintiff, who was the longtime mistress of a man who had passed away, brought a Marvin action against the widow, alleging that the deceased husband had promised her lifetime financial support in exchange for plaintiff acting as defendant's confidant, friend, travel companion, and lover. And the court ultimately found that the role as lover was an inseparable part of the consideration for the agreement, rendering it unenforceable in its entirety. So, the important lesson from Taylor is that it matters how you plead your claim. And you don't want to include any language in a complaint that could be perceived as sexual services being part of the consideration for the Marvin Agreement. So, when drafting a complaint, you might even want to include a specific line that sexual services were not part of any agreement.
And how do later cases define the analysis from Taylor?
Yeah, so the Taylor case made it clear that sexual services, agreements where sexual services were inseparable from the consideration would be invalid. But in a typical Marvin situation, the parties most likely have a sexual relationship. So that raises questions of how does the existence of that sexual relationship impact the enforceability of a Marvin agreement? And the Alderson case addressed that issue and said that the existence of a sexual relationship, even where both parties considered their sexual relations to be part of the role each assumed in the relationship, is not a sufficient basis to find the contract was rooted in providing meretricious sexual services. And the Della Zoppa case also examined this issue and found that a Marvin agreement will not be invalidated as a meretricious sexual relationship if the parties agree to have children together as part of the agreement. So the cases after Taylor made it pretty clear that in Marvin agreements, the existence of a sexual relationship alone is not going to invalidate the agreement.
Now, lots of us watching primarily focus on family law without maybe having the benefit of working on a palimony case. Can you talk with us about how a Marvin claim will coexist procedurally with the dissolution action?
Yeah, so it's not uncommon for Marvin actions to have crossover claims, and it's important to understand that a Marvin claim survives marriage. It's not extinguished simply because the parties marry. The Marvin agreement just applies to the period of time that predates the marriage. And we've talked a little bit about the date of breach, which is often at the termination of the relationship when one party ceases providing support. But when there's a dissolution case pending, the date of breach is often not the date of separation because one party is usually continuing to pay support during the pendency of the case. And in these situations, you might need to look at the declaration of disclosure or the schedule of assets and debts to see if one party is claiming that property acquired during the relationship prior to marriage is their separate property. And if they are, that's typically a good indication that that party's breaching the Marvin Agreement.
And
Another important point to keep in mind for dissolution actions is that you will likely be required to file a notice of related case if the actions involve the same parties and the same property. And the court also has discretion to consolidate the cases so that they can be heard together. And most times, when a notice of related case is filed, the Marvin action will be transferred to the family law department.
how does the breach analysis differ in a parentage case?
So, unlike dissolution matters where the timelines can be a little more complicated, in parentage cases, the date of breach is usually the end of the relationship, with some exceptions. So, if you're representing a client in a parentage action and you realize that they may have a Marvin claim, they need to move quickly to preserve it while the parentage case is still pending. And on the flip side of that, if you have a client in a parentage action, and you recognize they have exposure to a Marvin claim being filed against them, if you're engaging in any type of settlement discussions in the parentage action, it's going to be critical to make sure that you include a Civil Code 1542 waiver in any settlement agreement. So the takeaway here is that whenever you're handling a parentage matter, it's wise to do some early due diligence to determine if any significant property was acquired during the parties' relationship so that you can assess the likelihood of a Marvin claim.
Now, unlawful detainer actions probably arise, but why are those a poor fit for a Marvin dispute?
So these are quite common with Marvin claims. So when you have a party who's a title holder to real property, an unlawful detainer action can be used as a means to evict the non-title holder from the property. And these actions move very quickly. So if you have a non-title holder as a client, it's going to be crucial to act fast because there are things a Marvin plaintiff can do to delay the unlawful detainer action by either staying it or consolidating it with the Marvin action if real property is at issue. And it's generally recognized that the summary unlawful detainer action is not a suitable vehicle to try complicated ownership issues. And this is usually because, as a practical matter, the likelihood of someone being able to litigate issues of ownership to property within the constraints of an unlawful detainer case, it's not going to be great.
And how
And,
should
oh, sorry.
counsel approach those? How should counsel approach those types of consolidation or stays in unlawful detainer cases?
Yeah, so again, it needs to be done quickly. And there are procedural steps that need to be taken in order for a court to stay or consolidate these matters. And before that request can even be made, the cases usually need to be related. Otherwise, you can risk the court denying a stay or consolidation based on procedural grounds. And if you look at the Martin Bragg versus Moore case, that is clearly on point, which involved two long-term domestic partners who were involved in a dispute regarding real property. And in that situation, the court did determine that consolidation was appropriate.
How often do you see the unlawful detainer issue come up in practice?
Often. So anytime there's a real property dispute and the non-title holder is still in the property, I would say about 75% of the time an unlawful detainer action is filed. And this can really put a Marvin plaintiff in a tough position because most of the time they are the de facto out spouse and don't even have the ability to move out. I think it's also important to just add that requests for domestic violence restraining orders can also be quite common in these situations, especially when one party doesn't have the ability to move out of the shared residence. And while we all know no one would ever file a request for a domestic violence restraining order to gain an advantage in a civil litigation, I have seen situations um, where a party is unsuccessful in evicting a Marvin plaintiff and almost immediately thereafter files a request for a DVRO and they're able to get a move out order through that mechanism.
Now, let's talk about probate. What's the most important procedural step in preserving a Marvin claim in a probate action?
Yeah, so Marvin agreements are enforceable against an estate when one party to the agreement dies. But unlike the standard statute of limitations that would apply to written, oral, or implied agreements, a Marvin plaintiff is subject to the strict 1 year deadline to file a lawsuit for a Marvin claim against the estate. In order to preserve that claim, a Marvin plaintiff needs to go through the proper procedural steps of filing a creditor's claim and having it rejected prior to filing the lawsuit. And sometimes there's no probate case open, so a Marvin plaintiff might need to open that probate case in order to file a creditor's claim.
And a lot of us see putative spouse litigation in our practice. Can you tell us why is the intent to marry a critical distinction between Marvin and putative spouse claims?
Yeah, so a Marvin claim differs from a putative spouse claim because a putative spouse has to have a good faith belief that a valid legal marriage existed, meaning they had to have taken some affirmative steps to legalize the marriage. But in a Marvin claim, there's no requirement to create a legal marriage. And the claim is based solely off of agreement, whether that was a written, oral, or implied agreement.
And obviously, there's atros in divorce cases. It's not necessarily the case in Marvin's cases, but can you talk to us about how a lis pendens may function as a partial safeguard when atro protections are not available to Marvin litigants?
Yeah, so anytime there's a real property claim, a Marvin plaintiff can file a lease pendants, which functions to alert potential buyers that the property is subject to ongoing litigation, which will essentially dissuade buyers from wanting to buy the property given the risk. And unfortunately, this is really one of the only safeguards available to a Marvin plaintiff during the pendency of a case.
And does the court have the authority to award temporary spousal support in a Marvin claim on its own?
So the court lacks inherent equity power to award temporary spousal support. And what it comes down to is there's just no statutory authority providing Marvin litigants with the right to temporary support. And while there's injunctive relief, which is available to all civil litigants, a Marvin plaintiff would have to demonstrate all of the elements required for a preliminary injunction. And the need and ability to pay standard available to spouses in a family law situation is simply not going to satisfy the requirements for injunctive relief to provide temporary support to a party in a Marvin claim.
And how can practitioners navigate the limited right of recovery for attorney's fees in a Marvin case?
Yeah, so unlike dissolution actions, there's no statutory right to recovery of attorney's fees for a Marvin litigant. And because of this, it can be really cost prohibitive for a Marvin plaintiff to pursue a claim when they are typically the party with no money and no property. One way around this would be to modify the fee structure. Because Marvin claims are civil actions, an attorney can represent a client on a contingency fee basis, but unfortunately, not many attorneys do. And even if an attorney is willing to handle a Marvin action on a contingency, there's still other significant costs like expert fees. Many times, Marvin litigants still have the need for a forensic accountant to determine standard of living, or appraisers or economists to testify regarding quantum merit claims.
And can there be situations when financial discovery is restricted, and what can attorneys do about that in a Marvin case?
Yeah, so Marvin litigants are not spouses. So the ability of a Marvin plaintiff to obtain financial documents can be limited because the Marvin defendant can invoke their constitutional right to financial privacy. And the tax return privilege does apply to Marvin cases. So a few things that can be done here is maybe the parties can agree to a stipulated protective order. That's one way that you can get a Marvin defendant to produce some financial documents. Also, if the Marvin plaintiff can demonstrate that there was some type of waiver of expectation of privacy during the relationship, maybe they were conducting their financial affairs together, allowing access to all of their accounts, that might give rise to a waiver. And lastly, if there is an ongoing dissolution action or parentage action, you'll be able to obtain some financial documents in those cases.
Now, this is exciting. When might a jury trial be advantageous in a Marvin case?
So, in Marvin actions, it's no secret that jury trials can be risky because most people on that jury have likely been through a divorce or a bad breakup and will be judging the case through their own experience. So, whether Marvin litigants opt to have a jury trial is going to be very case specific. And for a plaintiff, they might want a jury trial if maybe their story is particularly compelling or if damages are likely to be substantial.
And how do you navigate confidentiality in a Marvin case?
So, because parties to Marvin agreements are not married, the marital communication and testimonial privileges do not apply, which is one reason why when you see settlement agreements in palimony matters, you often see confidentiality clauses to address the lack of the marital privileges.
And what is a way that a cohabitation agreement can either provide clarity or ease the way when a Marvin claim arises?
Yeah, so one way a party can avoid a Marvin claim is by having a cohabitation agreement. And when that's drafted properly, a cohabitation agreement functions the same way as a premarital agreement does in memorializing the parties' understanding regarding property and support and how those items are treated in the event the relationship terminates, so the parties can avoid a Marvin claim altogether.
And Sarah, what are the high-level takeaways that people should take from our discussion today about Marvin actions?
Well, if there's one takeaway from today's discussion, it's that Marvin claims are incredibly fact specific and timing matters. So if you think your client might have a potential Marvin claim, it's critical that they get legal advice early because the clock on the statute of limitations may already be running even if they don't realize it yet.
And we have time for maybe one question. One person asks, what would you agree that the best outcome for a Marvin case is to ask for a jury trial? I guess the idea is, should you always ask for a jury trial at the onset of a Marvin case?
Well, it's always a good idea to ask for a jury trial at the onset so you have the option. If you don't do that and you don't post your jury fees, there's always the possibility the court could deny a litigant a jury trial. So you always want to make sure you are preserving that right. The parties can always agree later whether or not they'd like to have a bench trial.
And a follow-up question to that is, if it's part dissolution, part Marvin, is the disso tried to the bench and the Marvin case is tried to the jury?
So the simple answer there is it can get complicated. And it all depends on how the court is willing to accommodate the parties. If both cases are within the family law department and the family law department can accommodate a jury trial, that's always one way that the cases can proceed. But if that family law department is not able to accommodate it, sometimes the Marvin action will be transferred back to civil court for adjudication by a jury.
Thank you so much, Sarah, for this enriching discussion. I know it's going to enhance every practitioner's toolbox and toolkit in approaching these cases. And we at the Beverly Hills Bar Association really appreciate all the time and effort that you put into this. Thank you so much.
Thank you.